Do you have contemporaneous examples, and by contemporaneous I mean shortly after the adoption of the 14th Amendment, where the states disqualified national candidates, not its own candidates, but national candidates?
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article I and Article II powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting federal officer. So what was the purpose of Section 3?
The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is, do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article II and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s.